Good afternoon, please be seated. All right, good afternoon. Welcome back to docket number 210701. So we are here this afternoon for a hearing with respect to the notice of violation issued to the United Illuminating Company, Connecticut Natural Gas Corporation, and the Southern Connecticut Gas Company. My name is Chairman Marissa Gillette. I'm joined virtually. Is Commissioner Karen? Oh. I'm joined by the Vice Chairman, Jack Pekoski, and we have an agenda in front of us today. I will begin by taking appearances. So we'll start with appearances for the company.
Thank you. Good afternoon. Robert Hum for the United Illuminating Company, Connecticut Natural Gas Corporation, and the Southern Connecticut Gas Company.
And good afternoon, Alex Soder on behalf of the Avangrid companies.
Thank you. Attorney Wheel, does OCC want to enter an appearance? Welcome. Thank you. Anyone else who wishes to enter an appearance at this time? Okay, I'm going to take up an administrative matter. Then I'll see if there are any other administrative matters. Believe the motion number is motion number 43. Let me start by asking if the company wishes to withdraw its motion or otherwise address it.
Thank you, Chairman Gillette. If I may return that with a question. I was obviously watching the morning portion of the hearing where you confirmed that this is a contested case proceeding and continuing pursuant to the contested case process. If that's the case, we don't have anything further to add. That is all that we're asking in our motion.
Okay. So if the, okay, I'm sorry. I know that sounds simple, but I just want to make sure that I have your position on the record. Okay, so this morning, the attorney for Eversource Companies and I went through a back and forth about what constitutes a contested case and the test for determining a contested case. And I understand you right now to say that if we're in agreement that a 1641 proceeding triggers the second, I think it's the second prong of that test, meaning that it is a contested proceeding. That is all that the Avangrid companies were seeking to confirm in your motion.
Yes, correct. From our perspective, that's all that we're seeking to confirm in our motion.
Okay. In that case, I will leave that there. We will be denying the motion since I mean, I leave it up to you.
Sure, I'm happy to elaborate too. And I understand that the morning's proceeding applied to Eversource and the afternoon's proceeding applies to Avangrid. So to the extent that's an issue, or to the extent you have any other questions, I will give my brief remarks, and then perhaps we can take it from there.
Okay. I'm happy to hear your brief remarks. I want to make sure that we are just totally on the same page. Because I think I had a different, I perhaps read your motion to be more expansive than what you were seeking, or you just stated that you're seeking. So why don't we take a couple steps back and give your remarks?
Sure, thank you. So I'll do that. So the purpose of our motion is simply to enter a procedural order to confirm that the authority is conducting this NOV proceeding for Avangrid as a contested case proceeding under the Uniform Administrative Procedures Act. And we do view this as a formality and really just a point of administrative clarification. If the authority confirms that this is a contested case proceeding, and this proceeding is going forward as a contested case proceeding would, then that's all that we are asking, and that's all that our motion intends to be asking the authority today. Our motion offers two suggestions in terms of how to go forward with that. I know there was discussion with Eversource this morning, but what we propose in our motion is, number one, to open a new docket and to move all of the NOV information into that docket, and then just continue essentially business as usual as a contested case proceeding would. Or alternatively, the second proposal in the motion was to issue an order specifically designating the NOV portion of this proceeding as a contested case proceeding for that administrative clarity. And the reason for that is because of the initial procedural order that had come out in docket 210701, I think it was a couple of years ago, did state that the proceeding was an uncontested proceeding. So now that there's an NOV within that same docket, it's to clarify that the NOV portion of the proceeding is a contested case and is going forward as a contested case would. From our perspective, this won't delay anything in the proceedings. Obviously, we're prepared to move forward today. We understand the briefing schedule moving forward. I think from our perspective, this provides administrative clarity to confirm that the NOV is a contested case pursuant to the applicable statute. So therefore, we ask that our motion be granted on those grounds.
Okay, I appreciate that. I do want to step through a couple of things then from this, the conversation I had this morning, just to make sure that we're clear on the record. So based on that and my reading of the motion, the companies, the avant-garde companies, are not alleging that the notice of violation itself was deficient in any of the four prongs that are articulated under 1641 subsection C, or are you?
We're alleging that the notice of violation had addressed each of the four prongs. If you give me a moment, I'll just pull them up. The notice of violation addresses the four prongs, reference to the sections of the title, regulation, or order involved, short and plain statement of the matter asserted or charged, statement of the prescribed civil penalty for the violation. I think specific to that, there was identification of the penalty. And then for the statement of the person's right to a hearing, which obviously Avangrid exercised its right, and that's what triggers our request to acknowledge this as a contested case.
Okay, thank you. So we're not alleging any deficiencies under 1641. And do the avant-garde companies want to challenge the discussion this morning was that nowhere in 1641 does the statute require that a notice of proceeding be issued, but rather that the notice of violation must conform to the four parameters that we just discussed under subsection C. So does the company accept that, or is the company alleging that a notice of proceeding is required for a notice of violation?
We're not making that argument. We're making the argument that that the NOV issued, we have responded to the NOV with the request for hearing and the pre-file testimony. We just want administrative clarification that this is in fact a contested case proceeding and will continue as a contested case proceeding.
Okay, I appreciate that. And we may be at a bit of an impasse, because I think what you hear from me is, speaking for myself, reading the case law and statutes, specifically High Wash Recovery Center versus DPH, which I think is just a few years old here. I read that to say that my words alone as the hearing officer cannot convert the proceeding into a contested proceeding, or conversely into an uncontested proceeding. Thus, it doesn't really matter what I say to you, but rather does the proceeding constitute a contested proceeding under the three-part test. So we may be at a bit of an impasse, because I'm saying I don't have the right to declare this contested or uncontested. It either is or isn't. I'll let you respond to that. Thank you,
and thank you for that nuanced clarification in terms of your position on what you can say or not. I agree that based on this statute, if statutorily it falls within a contested case proceeding, it is a contested case proceeding, whether you say it or not. But But for purposes of, and this is now maybe going back to what your question was in terms of the notice of proceeding. That's not the argument that we were making, but the way that the question that you just posed, I think is put forth today. I think there would need to be some kind of notice identifying this as the contested case. The only place I'm getting that from is from the Uniform Administrative Procedures Act. I think it's section 4-177, where I think it's part A states, in a contested case, all parties shall be afforded an opportunity for hearing after reasonable notice. The notice shall be in writing and shall include, et cetera, et cetera, et cetera. And I won't recite all that. So if the notice of proceeding, or I should say the notice of hearing in this case is intended to be that, and if this case is in fact a contested case, and if that's confirmed and it's proceeding as a contested case, then that's kind of the specific point that we're looking for in our motion. Does that make sense in response to your question?
I appreciate that. I'm still backed into the same corner I was this morning, which is there is no allegation that we have fallen short of any of the required parameters under 1641. The company has received an opportunity to file pre-file testimony, has received an opportunity to request a hearing, and in fact, we are here for a hearing, and the company is confirming that you're ready to proceed today. So if that's where we are, and there's nothing that you want to add to that, then we can probably leave this here and we'll reserve the ruling for a written ruling. But is there anything else that you want to add to that?
I think you summed up the position and the posture of this accurately there. The only question I have, and understanding your statement a few moments ago that, regardless of what you say, you can't say it either is or it isn't, which I agreed with. But let's say hypothetically, the authority were to issue a notice of proceeding. In that instance, you would be making an opinion that this is a contested case, and you would be putting it on the record that it is a contested case. So I think my only hesitancy in my responses to you, I think, is kind of that point there, that while we may have a discussion, today, and you may opine one way or another, there does need to be, I think, some kind of definitive statement for the record to clarify that it is a contested case. And whether it's like, for example, if you were to rule on a motion, as we sit here today, whether it's this motion or any motion, you would make your ruling, it would be granted, denied, whatever it is, you are making your ruling on the record. It'd be similar to that when you're opining on whether this is a contested case or not. I believe that would be some sort of ruling or some sort of affirmative statement from the chair that this is in fact a contested case, doing away with all ambiguity, making sure that the record is clarified, and making sure that there aren't any issues with that.
Okay. Thank you. Certainly the company has pursued litigation to Superior Court in which Pura has opined that a matter is uncontested, which by default would mean that you couldn't appeal to Superior Court. So what I'm getting at is I'm not sure what additional thing you're asking for, because if we opine one way or the other, you're still going to exercise or advise your client to exercise their appellate rights, even if I tell you right here that it's an uncontested matter. So I'm still really struggling with, this concept that you're seeking clarity, given that from where I'm sitting, I'm struggling to understand where your client has been prejudiced to begin with.
Yeah, thank you. And thank you for that example. That using that example with respect to the right to appeal, certainly if this were an uncontested proceeding, maybe there could be reasons why a party might appeal. I'm not saying what they are, who knows what they might be. I don't want to project. But if it's a contested case, then by law, there is that right to appeal. And I think that that's the difference, whether there's a right to appeal or whether there might be some kind of issue that you might need to argue would be appealed, but you don't have that right to appeal, and maybe you get rejected on appeal for that reason. So I think that's in this, we did have a very short statement in our motion with respect to due process. And that's only identifying the fact that if it's a contested case, certain rights follow. And I think we've already talked about the notice does kind of hit all the steps that it needs to. We're having our hearing today. Part of the motion is, ensuring that this is a hearing subject to a contested case as opposed to maybe a gratuitous hearing that might be in an uncontested case. So I think that's my response to that, and specific to the appellate issue. I think it just has to do with whether you have a statutory right to appeal or whether parties choose to appeal for whatever reason it may be.
I appreciate that. And we're probably way too far down a rabbit hole for everybody else in the room. I'm going to nitpick at this one more time and then
Okay.
we can move on. Just to continue that a little bit further though, I didn't hear you challenge what I said just a moment ago, which is whether I declare this uncontested or not from the bench, you would still presumably advise your client that they have appellate rights, given that 1641 subsection C subdivision 4 provides a right to a hearing. So I know I'm really hitting at something that probably sounds nuanced to everyone else, but again, I just keep coming back to, does it actually matter in terms of due process rights, whether I sit here and declare it contested or not, since we can both read 1641 subsection C subdivision 4, see that it requires a right to a hearing, apply the 3-part test to it, and then we are where we are. So any last thoughts on that?
Yeah, the only thing I'll respond to on that is, and I understand what you're saying about that, but the difference is, let's say there were an appeal. I think I agree with you. We would advise the clients that based on how the statutes read, this is a contested case. But on appeal, now that's an issue as to whether it's a contested case or not. Whereas if there were a definitive statement, some form of administrative clarity confirming that it is a contested case, then it's clear and there's no confusion from anybody. There's no confusion from whether it's the companies, whether it's one of the agencies, or whether it's from the court as to whether it actually is a contested case. That would be a non-litigated issue that would already be set.
Okay. All right. Thank you. I think we can leave that there, and we will take the motions under advisement. So does the company have any further administrative matters before we begin the hearing?
Not at this time, and we're ready to introduce our witnesses.
Thank you. One moment. Let me just check with OCC or others if there are administrative matters before we begin. No? Okay, thank you. All right, then if we can introduce the witnesses before I swear them in, please.
Thank you. So Avangrid calls Leona Michelson and Tracy Palella.
Oh, I'm sorry. That's me. Ladies, if you could please raise your right hand, I'm going to swear you in. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury.
I do.
Thank you.
Thank you. I'm going to start with Ms. Michelson. Can you please identify your full name and title for the record?
Leona Michelson, Manager of Research and Strategic Communications.
And on June 1st, 2023, did you submit pre-filed direct testimony and exhibits in this proceeding?
I did.
Do you have any changes to your pre-filed direct testimony or exhibits?
I do not.
Is the information provided in your pre-filed direct testimony and exhibits true and accurate to the best of your knowledge and belief?
Yes.
Do you adopt your pre-filed direct testimony and exhibits under oath today?
Yes.
Thank you.
Thank you.
Now, Ms.
You didn't do that.
I haven't done, I went in this order.
I'm sorry. Please proceed.
That's okay. Ms. Palella, please identify your full name and title for the record.
Tracy Palella, Vice President of Customer Service for the Avangrid Network Companies in Connecticut.
On June 1st, 2023, did you submit pre-filed direct testimony and exhibits in this proceeding?
I did.
Do you have any changes to your pre-filed direct testimony and exhibits?
I do not.
Is the information provided in your pre-filed direct testimony and exhibits true and accurate to the best of your knowledge and belief?
Yes,
And do you adopt your pre-filed direct testimony and exhibits under oath today?
I do.
And finally, Ms. Palella, do you have an opening statement to present to the authority today?
I do.
Thank you. So with that, Madam Chair, with your permission, I ask that Ms. Palella be permitted to read the opening statement on behalf of the company.
Please proceed.
Thank you. Good afternoon, Chairman Gillette, Vice Chairman Butkowski, Commissioner Karen, and Pura staff. I am Tracy Palella, the Vice President of Customer Service for the Avangrid Networks Companies located in Connecticut, And this is Leona Michelson, the Manager for Customer Research and Strategic Communications for Avangrid. We appreciate the opportunity to speak with you today, and we look forward to answering your questions about Avangrid's implementation of changes to its medical web portal and medical certification forms. The customer service and communications teams at Avangrid take a tremendous amount of pride in the work to serve customers. Customers are at the forefront of everything that we do. We work directly with customers on a daily basis to help them and make their lives easier when it comes to dealing with their electric and gas bills and opportunities to support their needs based on their life circumstances. We work tirelessly in these endeavors. Aside from that day-to-day work helping customers, we're also often called on to support regulatory filings and related matters. We take this work seriously too, and we strive to do our best to complete the work required of us by Pura efficiently and accurately. We acknowledge that we had some issues in implementing some of the directives in the final decision in this docket, particularly by using one term instead of another in some instances. We understand the importance of complying with regulatory orders issued by the authority, but we simply made some mistakes in our use of terminology. We immediately fixed those issues the first time we learned of them here, and we are always open and we welcome any advance notice or opportunity to correct any other technical issues. What we truly do not understand is that a notice of violation was issued and also the amount of the penalty where there is no indication of any harm or other impact, and the issues were easily corrected. Our team worked hard to implement all of the directives in the lengthy order in this docket. Out of the 49 enumerated orders that were applicable to Avangrid, we are alleged to have violated 2 of them, and even then, there's no allegation that we fully failed to complete those 2 orders, which is a rate of better than 95%. The authority's issues with the 2 orders involve mistakes in terminology and other technical issues, yet we are now faced with a substantial $480,000 penalty for these minor issues. The terminology and other technical issues were the results of human error in implementing the orders, but we do not understand why we are being penalized the maximum amount. Customers are the most important thing to us, and there's no indication that customers have been harmed by these minor issues. Customers cannot access or use the medical web portal. The portal is accessed and used solely by the physicians, physician assistants, and APRNs, and they are the ones who complete the medical certification forms. Even before the final decision, physicians, physician assistants, and APRNs all used the medical portal and completed the certification forms. We aren't aware of any indication that these medical professionals had any inability to access the medical web portal or confusion in using the portal or to complete a medical certification form as a result of the terminology differences or other technical issues. In other words, we aren't aware of any harm that occurred to customers or to the medical professionals on behalf of customers as a result of the differences in terminology or anything else. For that reason, we truly do not understand why we've been penalized the maximum amount for each alleged violation. Also, it's important to note that when we make administrative changes to the presentation of the medical web portal and the medical certification forms, we only make those changes once. We do not make the changes 3 separate times for each of the 3 Avangrid companies in Connecticut. Therefore, we also do not understand why we've been penalized 3 times for each single instance of the issues alleged in the NOV. We recognize we are not perfect, and we weren't perfect here. We also recognize there are always lessons learned and opportunities to improve. We've already implemented some process improvements as soon as we were made aware of the issue to address the human error and to help make sure they don't happen again. Our teams at Avangrid will continue to work hard for our customers and will do our best to continuously improve our performance. We hope that you take all of these factors into consideration when you are reviewing the notice of violation in this proceeding and either withdraw the notice of violation or significantly reduce the amount of penalties imposed. In closing, I thank you again for the opportunity to speak with you today. We're extremely proud of the work that our teams at Avangrid do to help customers, and we look forward to your questions. Thank you.
Thank you. Anything further before we turn to cross?
Nothing further. These witnesses are open for cross. Thank you.
Thank you. Any questions from authority staff today? Thank you, Ms. McDonald. Attorney Wheel. Thank you, Mr. Vice Chairman.
No cross.
Thank you. I just have a couple of questions. So Ms. Palella, I appreciate your opening statement. You had a couple of references to having corrected these violations the first time you learned of them. And I just want to make sure I heard that correctly. Is that what that was your statement?
Yes.
Okay, so when do you think was the first time you learned of these violations?
What I was referring to is the notice of violation.
Okay, when we have a draft decision, particularly in an affordability docket, is it common practice for you and your staff to review the written exceptions of other parties?
Yes.
Okay, so would it surprise you to hear then that the written exceptions for 220501's draft decision from, I want to say it was the Children's Center for Ava, made reference to these violations in their written exceptions, which were dated in October of 2022.
I recognize that there was a lot of feedback from the various stakeholders.
Okay, so I guess my point is it's not quite accurate to say that the first time you learned of the errors or the mistakes was in February of 2023, though, correct? I mean, that's the point
My statement was that was the first time we were aware that they were cited as violations and that we needed to correct them.
okay.
We were basically focused on the orders, and making sure that we complied with the orders.
Okay, so in the previous energy affordability proceeding, which was the 210701, where these instructions were provided, they were reiterated in the next year's affordability docket 220501. And that draft decision received written exceptions pointing out that the companies had not yet complied with the directives of 210701. So I'm just trying to understand, did the company review that and opt not to make the changes at that time until February of 2023 when the authority formally issued violations?
We review the draft decisions, we review the exceptions, and then we await the final decision. And then we try to abide by all of the compliance requirements of the final decision.
Okay. Okay, so maybe said another way, is the nuance that you're trying to draw out here? Because I understood from your opening statement, that the company's position is that the first time they learned that these errors existed was in February of 2023. And my point is, you did in fact know that these were mistakes or had not yet been rectified when you saw the written exceptions filed in October of 2022. So is the nuance that you're trying to draw out that you didn't know that the mistakes would then be transformed into violations, or I'm lost there?
The first time that the team became aware that we had these issues that we needed to rectify was after we received the notice of violation. We believed the follow through that we made in response to the docket and the orders that were presented to us, that we had implemented them all. But then we realized when we got the notice of violation that we had overlooked some.
Okay. This is the notice of violation and the docket 220501 and the docket 210701. Those were in fact preceded by another docket in which the company was alerted to feedback on medical and the company's interactions with medical protection customers. And I believe that docket is 171203 RE01 through the energy affordability 100-day sprints. Does that comport with your recollection? Did you participate in that docket?
I had some awareness of that docket at the time. Yes.
Okay, so you are aware that the authority has been looking into the company's interactions with medical protection, medical hardship, medical providers dating back at least to the start of those 100-day sprints.
Yes.
Okay. Okay, maybe just a slight pivot here to another clarification. I heard you refer in the notice of violation a couple of times to the authority levying the maximum amount. Can you help me understand what you mean by that? I'm not asking for a legal opinion, just factually, what do you mean by the maximum amount?
My understanding, based on the feedback from our Avangrid team, is that we were assessed the maximum penalty. So in other words, if there were a different kind of mistake, that there wouldn't be a higher level penalty assessed per instance, is my understanding.
Okay. Let me just 1 second here to pull this back up. Okay. Are you familiar with the Children's Center for Advocacy's correspondence in this matter? I think it might have been filed as a motion subsequent to the issuance of these notices of violation. Get you the motion number here. Motion number 35 filed on February 3rd, 2023. Motion to revise medical protection NOVs filed by the Center for Children's Advocacy. Is the company familiar? Are the company's witnesses familiar with this motion?
I'm familiar with it, but I don't have the content in front of me.
Okay. So I'm referencing it because I'm still trying to understand what you mean by the maximum penalty, because I think the maximum penalty would have been, a per day violation between when the orders were first issued and when the authority issued the notice of violation. So I'm just trying to understand what it means to you when we say when you assert that you received the maximum penalty.
As I stated before, my understanding based on the discussions with my Avangrid team members is that we received the maximum penalty as a per instance type of penalty. So if there wouldn't be a higher than $10,000 per instance, that's my understanding.
Okay. Not offered as a legal opinion, though. Let me direct that to your counsel.
Certainly not by me.
Is the company is not presenting these witnesses as legal witnesses.
No, Ms. Palella and Ms. Michelson are presented as fact witnesses.
Okay, all right, then I will leave that there. I don't have any further questions at this time. Does the company need an opportunity to consider redirect?
With your permission, may we have a few minutes to confer?
We will recess for 5 minutes.
Thank you.
And you may step out.
Great, thank you.
All right, council.
Thank you for that brief recess. We have no redirect.
Okay, very good. Thank you. In that case, let's turn to recapping next steps. We are scheduled for briefs on July 11th. We're tentatively scheduled for a final decision in this matter by September 6th at that regular meeting. I'll advise parties to keep a lookout on the external calendar in case the regular meeting date changes. Are there any closing administrative matters?
Yes, thank you. May I just ask one question about the briefs on July 11th?
Yes.
May we request a 1-week extension on that to July 18th? I'm going to be out of the office on vacation that week, including on July 11th, and would appreciate the additional time.
Okay, would any other party like to be heard in this matter? Okay, as a matter of best practice, I prefer motions for extension to be submitted in writing, so I don't see any issue with that sitting here, but I'd ask that you formally submit that in writing, because if we do adjust it, we will adjust it for all parties of record. So,
Great. Of course, we can do that.
all right, thank you very much. Anything further?
Not from us. Thank you.
All right, thank you. Then with that, I want to thank the witnesses for your participation today, and we are adjourned.